Attorney Professor Gregg Macey is up next. Professor Macey is the director of the Center of the Land, Environment, and Natural Resources at the UC Irvine School of Law. He has been the main force behind bringing the People's Tribunal together, and we are so pleased to have him with us here today for the next piece of our march towards justice with the advisory opinion. What do we want?
Justice!
Yes, Dr. Macey.
Thank you all for coming today. We really appreciate the attention that you're giving to these issues. It doesn't receive nearly enough coverage. When I was a law student, sometimes the professors would teach a class using what they call a case study, and to teach them about how the law works. One of those case studies is something that I learned as a law student. It was called Childhood Cancer Clusters in California's Central Valley. This was a case study that was written by Stanford University in 1998. Can you believe that's a quarter century ago? And I don't remember why the professor assigned it. I just remember how it made me feel to read that case study. It was all about government officials spending years trying to investigate these cancer clusters in communities like McFarland, all in the Central Valley. And then it quoted these government officials. You know, it had quotes like, we did not find a specific cause, but we did not disprove any cause either. It also quoted residents of the Central Valley. Remember, this is 1998. It quoted residents saying that the investigation made them feel abandoned. One of the residents said, "We have this cloud over us. We were hoping that an explanation would come and chase the cloud away." The case study concluded, and I had to look this up the other day just to believe it. The case study concluded, years of epidemiological research has yet to produce a smoking gun. Now, that was 1998, and the science, epidemiology, and law of pesticide use and impacts has grown by leaps and bounds since then. But their application to protect people on the ground every day has not grown by leaps and bounds. How do we know this? 1 year after that case study was written, some of you recall, a complaint was filed with EPA. It was called Angelita C. versus the Department of Pesticide Regulation. It claimed in 1999 that students who attended schools within 1.5 miles of agricultural applications of methyl bromide were being discriminated against. That complaint, filed in 1999, languished at EPA until 2012. In 2012, EPA, having conducted this very sophisticated statistical analysis, issued its first ever preliminary finding of discrimination under Title VI of the Civil Rights Act of 1964. Unfortunately, they then settled that complaint with DPR without the involvement of the complainants, and almost nothing changed on the ground. The experience was so dispiriting that the organization that was involved in bringing this complaint, the Center on Race, Poverty, and the Environment, they actually wrote a report after that whole experience, outlining what happened within EPA, which led to no changes on the ground. The report, which I really encourage you to look up, it's called A Right Without a Remedy. And again, that was a quarter century ago where that complaint was filed. And this theme of a right without a remedy extends to the present. And it extends specifically with regards to California civil rights law. And that's what we're talking about today. Specifically, if you start looking into California civil rights law, especially California Government Code section 11135, you're first met with optimism. You realize that California's civil rights laws are more expansive than federal civil rights law. You realize that you can bring a cause of action not just for intentional discrimination, but discriminatory impacts. Specifically, that law says that if a California operated or run program or activity, or a California funded program or activity engages in discrimination according to one or more protected classes, that is illegal. And protected classes, there are many more protected classes in California civil rights law than in federal law. So this could be according to race, national origin, ethnic group identification, and a whole host of other categories. And yet, even though that state law was on the books since the 70s, we only have a handful of cases where a court has decided on the merits whether there was a civil rights violation regarding an environmental harm. And so you start to think, why is that? What is getting in the way of civil rights law being enforced? Well, there are many reasons. Unfortunately, we don't have time for all of them today, but one of them that you could all imagine is how complex these claims can be, right? Imagine the epidemiological, geospatial, and other forms of data that you would have to marshal, and importantly, that agencies would have to analyze in order to decide whether there is a violation of civil rights. But here's the hopeful element. And I know this is like crushing morosity so far. The hopeful element is in California, it's not just civil rights law sitting out by itself. It is implemented according to state regulations. And state regulations say that one definition of discrimination, according to state civil rights law, is when a program or activity engages in methods of administration that have the purpose or effect of substantially impairing that program or defeating that program as it is designed to protect one or more protected classes. And this is important because who knows more about the daily practices of pesticide use and attempted regulation? Not the lawyers, not the epidemiologists, but the people. But farm workers, their families, and their children. And for the past year and change, I've had the great privilege of meeting with and working with a statewide coalition for pesticide reform that for decades has gathered information about those daily practices, often with little fanfare. And we've had the privilege of meeting with that coalition. We've had the privilege of interviewing people who are experts in pesticide, the science of pesticide use and impacts, and the regulation of pesticide use and impacts. But we didn't want to just stop at interviewing people, right? Interviews, even when they're carried out with great care, they can be isolating, they can be extractive. And so we organized the People's Tribunal in the fall to give people a chance to come and testify about their experience without the strictures of a courtroom or a legislature or a very precise issue that people are normally focused on in those proceedings, right? And as Jane said, the results were shocking, but not surprising. And so the combined testimony of the People's Tribunal and the interviews that we conducted inform the advisory opinion that you have before you today. And what did they say? Time and time again, people providing testimony and farm workers whom we interviewed, they gave us a sense of a series of practices that impair or substantially defeat state-funded and state-operated programs. They told us not just about a breakdown of notification, reporting, and complaint processing due to language barriers, a culture of fear, isolation, misinformation, intimidation, and retaliation. And they talked about how this breakdown in notification, reporting, and complaint processing led necessarily to certain results. Because of this dynamic that farm workers and their families experience every single day, the Department of Pesticide Regulation and the county agricultural commissioners do not receive the vast majority of reports or complaints that they would otherwise receive from Latino and transnational indigenous communities. They miss multiple opportunities to find that health hazards appear generally within those communities, which should trigger field inspections and potentially canceling permits. They do not ensure that warnings, trainings, and other essential protections for Latino and transnational indigenous farm workers are equally available. They do not give adequate attention to local conditions, including the effects that pesticides have on Latino and transnational indigenous communities when they grant permit approvals. And they fail to reevaluate pesticides and whether current practices must change when there is reason to believe that they cause unreasonable adverse effects on people and the environment. These dynamics are ongoing, they are pervasive, they are heartbreaking, and they do not require lawyers or epidemiologists to prove. Farm workers and their families have known about them for generations, and we call upon the California Attorney General's office to investigate these practices that substantially impair or defeat multiple programs designed to protect the public. Thank you.
Thank you, Dr. Macey. And just to highlight, like Dr. Macey mentioned in his amazing speech, he talked about the Angelita case that happened here in Watsonville, in one of the schools, Ohlone Elementary. So we really want to highlight the continuous racism that is existing in our community. So thank you for that, Dr. Macey.
You mentioned cancer clusters. What is a cancer cluster?
Cancer cluster, according to what I learned 20 years ago, is a group of cancer cases, often with rare forms of cancer, often with individuals having more than one form of cancer at the same time. And they are groups of cancer cases in a geographic location that should not occur by chance alone, meaning that there is some other cause aside from chance that produces them. And because of the small numbers of people involved, it's very difficult to prove that there is a single cause of a single cancer cluster. And actually, I think there's only one case in the history of the country where a court found that a single corporation contributed to a single cancer cluster. And so that's why we're focused on other issues here. We're focused on what is happening every single day to impair or defeat regulatory programs that say they are designed to protect public health. If those programs are not in place, then I don't know what we're doing. Yes, sir.
Are there particular crops that are more heavily rely on pesticides?
I'm Mark Weller. I work for Californians for Pesticide Reform, and there are almost anything that's grown now in California has pesticides applied. In this region, I think we're concerned about fumigants and organophosphates. And fumigants, as you know, are applied before berries are planted. So that's a big concern in this region. And organophosphates, a quarter of all organophosphates that are used in the state are used in Monterey County alone. And they're used on, again, many different kinds of crops. So I'm sorry I can't give a specific answer to which crops are the worst, but I can tell you that all of them have pesticides used on them that are of concern.
Thank you.
Thank you, Mark. And you know that's really important. Your question is really important because even if in some mythical world all of these regulatory programs were implemented according to civil rights law, we would still have a problem. If you think about just one example alone, you know, we have these requirements for re-entry intervals, right? The amount of time after a pesticide is sprayed before farm workers can re-enter an area. And I remember when those re-entry intervals were first developed, and they're developed with a variety of assumptions. Remember, this is assuming perfect regulation, and we are here today talking about all the ways in which regulatory programs are imperfect or absent, right? But even in a perfect world, A re-entry interval is calculated based on a single active ingredient, assuming a 154-pound white male with no pre-existing conditions is entering the field, is not subjected to any synergistic effects of all the other ingredients surrounding them. And so even in a perfect world, our regulations leave certain people more protected than others. And that's the message. That's the message that everyone behind me has known for generations. And it's almost like I shouldn't be here. You don't need me here. You know everything you need to know to report on this issue, to report on the abject failures of the state and the county agricultural commissioners. And we just need people to continue to report on this so that riding the wave of your reporting, we can have some meetings with the California Attorney General's office. We can meet with their Bureau of Environmental Justice, which, by the way, when Vice President Kamala Harris was the California Attorney General, she issued a memo that you can find online that said, how do we advance environmental justice in California, which of course is codified in state law, right? It is required that we pursue environmental justice. She had a memo that said, how do we advance environmental justice? And she said there are two primary ways in which we should do it. The California Environmental Quality Act and California Government Code Section 11135, California Civil Rights Law. She said that years ago, and still to this day, the California Attorney General's office is not making sufficient use of that and actually enforcing it vis-a-vis the Department of Pesticide Regulation and individual county agricultural commissioners. That's why we're here today. And of course, this is a first step, as everybody said, right? Civil rights claims are better the more precise they are. And so you should see that advisory opinion as presenting evidence that over the next few months will be more precisely developed. But we need the state's help. We need the state to do its job and to help us, right? We don't have the state's power of investigation and enforcement. We can point the way toward these violations, but we need the Attorney General to help us investigate them and enact hearings, administrative hearings, with regards to these counties in particular, and with regards to the Department of Pesticide Regulation. Why are we asking for all of this to be done vis-a-vis these agencies? Because, again, agencies, state-operated programs, state-funded programs are not supposed to use state funds to discriminate. They are not supposed to do that. That's what the law says. But if we don't do anything about it, we don't have civil rights laws. We just have words on paper. That's why we're here.